the phone. I've concentrated on trigonometry. I've done calculus mainly. I believe they concentrated on calculus last year.
Good morning, ladies and gentlemen. My name is Clerk R. David. They call me TR in America. India friends call me David, so it doesn't make any difference what you call it. I've been fighting a case in the United States for the last 40 years. It's a civil rights case. Okay? Now, I was kept busy by my employer, one of the largest corporations in the world. The company is called American Telephone and Telegraph Company, or AT&T in short. I will get to the facts of the case first, then I will tell you how they kept me in the kangaroo courts of the United States for the past 40 years. I was born and brought up in India. I went to colleges and law schools in India. I left India in the year 1968 for England to join my wife, whom I married a few months earlier, from India. I worked in England for a period of 7 years for the British Post Office. I was a Post and Telegraph officer. In 1974, me and my wife and our 3 daughters who were all born in England, we migrated to the United States. Although the children didn't come with us immediately, they came later. And when I reached Detroit, Michigan, I went for an interview with a company called Michigan Bell, which was one of the subsidiaries of AT&T. I was selected the very first day, although I had to wait a few days to get my social security number, which came later on. So they gave me a test for 2-3 hours, but I had to wait until I got my social security number later. But another place hired me the same day without social security, and then I worked there for a week or two. When I got my social, I joined the Michigan Bell. After working there for a period of 6 months, my immediate supervisor by the name Jack Timble found me way overqualified. They were remotely watching employees, generally, maybe me in particular. So he called me to his office and told me that he is very much impressed with my work habits, a lot of things, and he asked me what job you think you are qualified for to work for the Michigan Bell. So I explained to him back in India I used to work as a secretary for a major insurance carrier by the name New India Assurance Company in Connaught Place, New Delhi. I also happened to work part-time for a retired Chief Justice of India at his residence from 8 to 10. Then I went to my work, regular work, and then I studied in the evening classes for my degree and 3 years law. So this guy said, Mr. Oh, David, you have a secretarial skills. I would like you to take a test. He sent me for a test. I passed the test in flying colors, and they sent me to work for a a division manager by the name David Bartz, B-A-R-T-Z. Upon entering his office, he said to Mr. David, I always said traditional females, I don't want a male as my secretary, which is in violation of the law. And the central personnel insisted that he hires me as his secretary, because the company had as many as 600 females, all are secretaries working for one person or the other. So I was the first sacrificial lamb as a male secretary to work for a division manager who openly said he doesn't want me. He wants young girls for whatever purpose. You can, reach your own conclusions. At the insistence of the central personnel, I was hired by this guy for a week or less than a week, and he said at the end, Mr. David, you are not suitable for my purpose. I did ask him what his purpose was in having a secretary. And he sent me back to the department I was working. When I went there, my colleagues told me, this is very unfair, Mr. David. You should not have done this, and you should rather go and make a complaint with the internal EEO. Within the company, there is an internal EEO. There are about 90,000 employees, and there is a tug of war all the time between the blacks and the whites. That's the problem there in Detroit. So, at the insistence of my colleagues, I went to the EEO in the company. So they said, Mr. David, we can't investigate. This guy is 4 levels above us. So they referred me to the government's, the US government's EEOC. That's the only agency known to me then and much later. They came down to the office, investigated, found the employer in violation of the sex discrimination, gender discrimination, and ordered them to reinstate me and pay me a compensation, which the employer conceded. They paid me a compensation as ordered, and I was sent to work for 4 different managers. One a German, the other one a French, the third one a local American black, and the 4th one a American white. All of them found me shortly I'm way overqualified. The white gentleman, his name is Hank Hudson, he said to me, Mr. David, there are 2 ways to get promoted within the company. One, you nominate yourself. B, I recommend you. So I said to him, you do it. So I was sent for a 3-day management assessment program at which I got a perfect score. They watch you remotely, how you handle in-basket performance, how you communicate, how you give priority. There are a lot of 10 areas they check you. So I got perfect score, but the company will not reveal my test result for 1 year until I requested in writing. So a gentleman by the name Shepard came to me and said, Mr. David, you have passed the test in flying colors, but that doesn't mean you are promotable. You are never promotable. That is the expression he used. So I asked him, what is the reason? Is it because I filed a prior EEOC complaint? So he was keeping quiet. That is the reason. They can't retaliate under the law. They retaliated by failing to disclose my test result until after 1 year. So I was forced to file a second EEOC charge against them. And while the matter was pending, my immediate supervisor, who I didn't know was the US attorney's wife, she called me and told me, Mr. David, there is an opening for you to work in Florida, where AT&T is running their office. So I was asked, are you interested in going there and to work for AT&T? I said, yes, ma'am. They ordered me to get a ticket from the travel department within the company. They gave me a first-class ticket to fly to Florida. I was interviewed by AT&T officials. They told me to start from April 1, 1979. Simple. Now, the agreement, there was a tri-party agreement between me, AT&T and Michigan Bell, wherein they said, I will work for AT&T for a period of 5 years minimum, which can be extended if need be between the parties. And they will pay all the cost and expenses, moving costs, sale of my home in Michigan, and moving my furniture and everything, all my household items, which they did. I went to Florida. I stayed in a hotel for a period of 3 months at their cost. And I bought a house, a 5-bedroom house with a swimming pool and everything, with all the facilities. And I moved my wife and children. We were living there. I continued there for a period of 2.5 years. I got a raise every 6 months because I was paid much less than the other employees. I being perhaps a newly promoted employee, but we were all titled as legal analyst. None of them, to the best of my knowledge, had any legal training as I had, but I was getting low pay. I didn't grumble. I accepted because it's a promotion. 3 years went by, 2.5 years went by when AT&T and U.S. Department of Justice agreed for the break of AT&T because the U.S. Department of Justice was conducting a case against AT&T to break up their monopoly. So they agreed to the breakup, both U.S. DOJ and AT&T. So one fine morning, the division manager of Michigan Bell came to Florida, offered me $35,000 to quit my job. At the time I had small children aged 3, 7, 9, 11, and my dependent father and my wife. So we didn't want to quit the job because you have a permanent income and a lot of benefits. So I said to the person who came, his name is Richard Stone, sir, we don't want the money. We wanted to continue in the job, and if there is no opening there, then I may be taken back to Michigan as per the agreement. So I left after the meeting. That day he called me again around 7:30 and then on the phone and told me, Mr. David, come tomorrow for another meeting and bring your wife with you. I was under the impression I had applied for an assignment in Saudi, so they were going to indoctrinate you the customs and procedures in Saudi. Thinking in good faith this is an interview for indoctrination of us, me and my wife went there. So he said, Mr. David, yesterday I offered you $35,000. I'll give you $45,000. You want to take it? I'll give you 5 minutes time. And he left. And he came back maybe 10 minutes later. So we told him, sir, we don't want the money. We want to continue. Then he got up and said, Mr. David, you are fired. There is absolutely no reason to pick me up alone, being a person of Indian origin, and fire me without a cause. Because the Monday morning I was given a $5,000 merit increase and a fully satisfactory job performance. So there is no reason, absolutely no legal basis to fire me from my job. Folks, that is a violation of the law, terminating somebody from a job without a cause. When I went back to AT&T premises to pick my personal stuff from the office, they had disabled my key to enter the building, but somebody let me in, and I was given a letter from my boss, my immediate boss, who is also from Michigan Bell, saying that I've been transferred, that's the word, transferred, from Michigan Bell, from AT&T to Michigan Bell. This is after I was told I'm fired. Me and my wife, we came in literally in tears. I just want you folks to understand the name of the game going on. At that time, AT&T was and still continues to be a federal contractor who had taken lot of or provided a lot of services to the US government. So they are deemed or considered as a federal contractor. The law to be applied is called OFCCP, Office of the Federal Contractor Compliance Program. We didn't know at the time of my termination, there is such a law exists. Nobody knew. Nobody. Okay. So what people do is when you are fired, you go to the what is called the EEOC. In my case, after I was fired, we went there on a picket, and we picketed. Before we picketed, I was sitting in my home preparing the stuff for the picketing along with my children. AT&T sent one of their undercover agents by the name James R. Williams, who always carried a gun at that time. Now there is a problem, you can't carry a gun. He came, he started talking, and then he became very, very rude and aggressive, started shouting. My father came running, hearing the noise, and my children and wife. So he said in his broken English, "Get out." So this guy left without harming us. The next day, we picketed in front of AT&T, okay, to show our anger and frustration because they fired you without a cause. So it was on primetime television and in several newspapers, Orlando Sentinel and others. The television said the little David's fight against the mighty Goliath. Folks, in America, unless you know, you get paid every week if you are a regular employee. If you are a management employee, you get paid every 2 weeks. Okay? Unlike in India, you get paid once a month. Employees, in any company or government jobs. America, it is 2 weeks for management and non-management every week. So I have no means to feed my small children, okay? Under the laws, under the internal operating procedure of these companies, if they fire you without a cause, they have to give you what is called severance pay. The employer refused to give me my severance pay for 7+ years, around 8 months severance pay. I asked them to sell my home pursuant to the agreement. At that time, the interest rate had skyrocketed to 20%, never in the history of America. So there were no buyers to sell my home, and they were obligated to sell my home and pay me the market price after appraised by 3 independent appraisers, which they don't want to do. They don't want to pay me any compensation. They don't want to pay me my severance pay. They don't want to sell my home. They literally held me and my small children and my father and my wife to economic ransom and blackmail. Okay, this is their tactics. It's a major corporation in America. People should know As of today, 2,211,000 people have died. America will run out of labor force. Okay? So these tactics were employed by one of the major corporations in America unashamedly. Because they don't care a damn. Everybody is a number in their game. The chairman of this company is retiring as from January. $77 million, that is his compensation package. But as of today, I haven't received a dime. Okay? I'm a worker working for this corporation. They haven't given me a dime. So folks, what I did was, I filed a complaint with the then known agency, EEOC. I didn't know at that time there was another agency called OFCCP Access. Nobody knew. Okay, the only people who knew is within the Department of Labor. Now this agency is supposed to investigate the illegal termination of my employment, because I was at the time over the age of 40. So there is a law called age discrimination. There is a law based on Title VII, which is called discrimination based on national origin, color. I went to the agency, I filed a complaint with them. They never ever investigated this. Okay? The Tampa office of the agency sent my complaint to the Detroit office, and the Detroit office issued me what is called a right to sue letter. So what happened was, in the meantime, before they issued the right to sue letter, after picketing, I went to Michigan to see my friends on my own. I asked them, can you give me my job or can you give me the benefits? They said no. So I had no other option but to feed my children. I signed what is called a release. The release stated, I quit the job. Folks, you got to understand, I am fired in the presence of my wife. We picketed. Now they want me to sign a letter saying that I quit the job. I had no option. I am forced to sign the release under extreme duress, coercion, and through fraud. Biggest corporation in America, how they conduct their affairs. Folks, this agency never investigated. They were told Mr. David signed a release, he quit the job. So they took it for granted that for gospel truth. They never bothered to contact me to find out, you signed it, is it true or false? Did you sign it under duress? Do we have to investigate? They never bothered, because all these agencies were playing in cahoots with major employers, AT&T being the largest employer, then employing over 1 million people. So what the agency did was, they gave me what is called a right to sue letter. That means I can sue the employer in a court of law. Folks, I filed a pro se action. Pro se means I am acting as my own counsel, and I filed the case in the Orlando District Court, alleging violation of my Title VII and the ADEA and breach of contract claims. The defendants, AT&T, Michigan Bell, moved the court to dismiss my case, interposing release as a defense. They are saying, hey, Mr. David, we fired him, but he signed the release. So, two issues here. Did they fire me illegally in violation of the law? And did I sign the release freely, voluntarily, and knowingly? That is the standard laid down by the US Supreme Court in another case called Alexander versus Gardner, Denver. So the judge denied their motion to dismiss. Motion means their request to dismiss the case, and the judge ruled that he will conduct a bifurcated trial to determine whether the release is valid or not before considering my Title VII, ADA, and breach of contract claims. By that time, I had engaged a lawyer from Chicago by the name Cyriac D. Capel. Cyriac D. Capel was a well-known figure in the legal system. He had previously argued the case of the Indian Prime Minister Morarji Desai in a defamation case where he was allegedly was a CIA agent. So he was well known in the circle. He was also the president of the Catholic Association at that time, which I didn't know. I later on discovered this. So once he came on board, the defendants attempted to bribe him. First, they propounded 1,300 requests to admit or interrogatories, which is overly broad and burdensome. Capel answered the interrogatories or request to admit, although it is beyond the scope. Nobody propound that many questions in our interrogatories. Normally the procedure is to take the deposition. Then they conducted him, they wanted to offer him some cases to be handled on their behalf, which is a clear case of bribery, giving him, inducing my counsel to handle their cases. And he said to them, no, I am not interested. Later on I went to his office in Chicago. When I was sitting in his office and he was on the phone rang, the local telephone. So he told me, pick up the phone, Mr. David. His wife was in another room. I picked up and they said they are from the Bar Council, Cook County Bar Council, want to talk to Mr. Capel. I handed over the phone to him and I heard him say, not interested, 2 or 3 times, because they were offering him a judicial position as a district judge in Cook County. This is their usual tactics. If you find the lawyer competent, they will hire him as their counsel or install that lawyer as a judge so they can deal. That's the name of the game, which I didn't know at that time. The lawyers don't work for nothing. Lawyers have to get paid up front. And somebody who is still laid off or terminated, they don't have the money to pay the lawyer. And when you fight against a major corporation like AT&T, you got to pay the lawyers big money, because what they do is they generate motion. Motion means request after request, keep you busy until you get tired paying the lawyer. Because if you don't have a job, if you don't have the money, you can't feed the lawyer to prosecute your case. That's the name, that's the reality of life. Those who have fought in the system, they know what I'm talking. Luckily, I had some legal training and knowledge from India. So when Capel said he wanted a lot of money, I said, sir, I can't. And in the meantime, I was going through a divorce. So I'm completely broke. Okay? Good morning, I'm having some tea. So, me and Capel agreed to be recused from the case, and I took over. Later I learned he was murdered. I can't prove AT&T was directly or indirectly involved, okay, which I came to know 3 or 4 years later when I was living in New York. I moved from Florida to New York, and this guy is in Chicago. Now folks, what happened was the defendants, AT&T and Michigan Bell, contrived under the plan. You got to understand, they don't want to deal with you in good faith, resolve the matter. An employee who worked for them, who didn't do anything except to ask enforcement of the laws. That's my most grievous fault. Going to the EEOC, reporting the guy, he wants young girls and he doesn't want me, that's not a crime. Okay, discrimination based on gender. Now, what these guys did was, the case was, as I told you, assigned to John Reed. He's dead now, 3-4 years, so he's dead. I believe natural causes. But the defendant wanted to have another deal with the judge, trial judge. To do that, they secretly hired the judge's former law clerk, a woman by the name Ann C. Conway. She was 31 years old, based on information from the Google. She was 31. So they secretly hired this young woman, 31-year-old woman, and sent her to the judge's home. Judge went to her home. They were meeting each other at their places and in Atlanta. Maybe she may have given the judge TLC, or what we call sex, or money, bribe, to have the case decided in their favor, or both. We don't know. If you go to the trial judge's home by the defendant's counsel, that is flagrant violation of the canons of ethics. Okay? And she was doing this, we have record to prove, although they later on destroyed those records. Because I was smart enough, I had the files later on sent to New York at the instance of the Chief Justice John Roberts. So I made some copies, relevant copies. Later on, when I asked for a certified copy, they don't have the file, it's missing. Okay, so what happened was, after this woman came on board, without knowledge to me, I don't know anything about it, just a woman coming to represent the defendant. I knew nothing about this woman. Judge says, come into my chambers. He doesn't want to conduct any proceedings in the open court. The reason being, a lot of lawyers know who this woman is. She was previously working with the judge. So judge wants to cover up. So he called me to his chambers. This woman will sit there like as if she knew nothing, pretend, it's all game. And the judge will bullshit, and the status conference over. He had another status conference, and in that status conference, he called the court reporter, the court stenographer, and started dictating, saying there is a triable issue of material facts exist in the case. That means you can't dismiss the case based on pure paperwork. The case has to be tried before a jury, which is what I had demanded. So that meeting is over. No offer for settlement, nothing. Okay? Then I began to become suspicious. Excuse me. I became suspicious, and I wanted to find out some additional information from this judge. I'm living in New York. This judge is in Florida, Orlando. I sent the judge a questionnaire seeking information, 20 questions in one questionnaire. And as soon as this judge got this questionnaire, He called me on the phone, a sitting federal judge calling a little guy like me. I am not even a lawyer. He called a pro se litigant to his home where I was living in Yonkers with a friend of mine. And who called me first was his new law clerk. I forgot his name, it's a male. And he said, Judge Reed wants to speak to you, Mr. David. He handed over the phone to him. Judge said he identified himself as the district judge for the Middle District of Florida, John Reed. And he said, Mr. David, I got your questionnaire. I'm not going to answer that in writing, but I will give you answers over the phone. A sitting federal judge calling a non-lawyer to his home. You got to understand, folks. Have you ever heard of that in the annals of civilized litigation in America or anywhere in the world? Then he admitted he was meeting this woman at his home, her home, and in Atlanta. At that time, according to the research, United States judges made $72,000 a year. Okay, 72,000. It is quite inadequate for them to survive. So they are susceptible to corruption. Okay. As soon as this judge made this admission, he said he is also a shareholder of this company, AT&T. He had worked for a subsidiary of AT&T, a company called Southern Bell in Florida, before he became a judge. I notified the FBI in Orlando. Also sent a complaint to the Chief Justice Warren Burger at the US Supreme Court. Warren Burger was a terror to many of the lawyers, crooked lawyers, because they don't like him. He is doing his job pursuant to the rules. As soon as Chief Justice Warren Burger then got my complaint, he apparently told this Judge John Reed to recuse and resign. Within a few days after my complaint, I got a letter from Judge Reed saying he is recusing from the case. We will show you a copy of the letter as we speak. He also resigned from the bench and he went to work for another law firm locally as his partner to where AT&T was giving their relocating employee cases as a kickback. You have to understand what is going on in the courts. AT&T claims I quit the job. And the judge wanted to conduct a trial. He doesn't want to conduct a trial now after they brought this woman. Okay? Now, what AT&T does is, you have to understand the game, the football game here. That court in Orlando had 6 judges in the Orlando Federal District Court at that time. If a judge resigns, dies, or becomes ill, under the local rules, the case should be reassigned to one of the judges in the same court, or should be sent to where I am living. So, what happened was, I got a letter from Judge Hodges telling me to come to his court for a status conference because this case has been assigned to him by the recused judge. So when being a court's order, I went to Tampa from New York, incurring costs. Okay? When I went there, on the notice board, there is a notice saying that no other hearing today, and additional security needed. Folks, this is a civil rights case. I'm not a criminal defendant wanted by anybody. In fact, I was cleared by the FBI a year earlier, and I was working for the Internal Revenue Service in Miami, Appeals Division. I don't even have a parking ticket to my credit. So this judge treated me with a bias, prejudice. That should not have been the conduct of a federal judge. There is a canons of ethics. You will see the canons of ethics, what judges are required to follow. The rules also stated that a judge should conduct these proceedings within 3 years. You can't keep it 39 years as here. Okay? So when I reached the courtroom, I was guarded by the marshals one side, the FBI agents, the courtroom deputies surrounding me, with the guns in their pockets, on their, on their hip pocket. And then this judge comes. The marshal says, "All rise." So we all rise and sit down. Say, "Mr. David, this case has been assigned to me by Judge Reed. I am the judge in this case from today on." I rose to say, "Your Honor, you do not have jurisdiction over me. I don't live in Tampa. I live in New York. You have no geographical jurisdiction or personal jurisdiction." I says, "No, Mr. David, this case is assigned to me." No judge should have any interest in the outcome of a case unless he is fed. You understand? This judge had no jurisdiction over me. I live in New York. I went to Clearwater once with my children for fishing. That's the only connection I have with the Tampa. Okay, that should not be the basis to assert jurisdiction. I told the judge in that meeting, "Judge, I live in New York. The AT&T has their headquarters in New York, 190 Broadway. Transfer the case." He said, "No, Mr. David." That's the end of the meeting. That is the only meeting in 39 years. You got to understand. Only meeting before this, I don't want to use the expression, the F judge in 39 years. So what he does is, he is in collusion with the employer. In collusion, you have to understand. He does nothing. Okay? In the meantime, AT&T and Michigan Bell, in collusion with among each other, terminated the service of another employee by the name Orville E. McDonald. McDonald was a division manager from Michigan Bell working for AT&T in their New Jersey facilities. So what AT&T does is they fire him, give him $12,000, and this is all scheme, well orchestrated scheme by all the players. McDonald goes to the state court rather than the federal court, and that court says in a per curiam unpublished order, one-man order, that McDonald must refund the money, the $12,000 paid to him, before he can sue them. As soon as these defendants get a copy, defendants counsel, Ann Conway and Peter Wolfson Zinneber, they are their two mighty gladiators, they move the court with a motion to dismiss my claims based on this hatched case. Folks, those who are lawyers, you know, there's a Federal Rules of Civil Procedure, 56. That says what are the procedure to be followed by the movement to get the case dismissed. They have to give a notice, time, place, date. This judge doesn't follow any of the rules. He thinks these rules, Federal Rules of Civil Procedures, are for fools. So as soon as he gets this Michigan court's per curiam unpublished order and opinion, he issues an order right away. No time for me to respond. I was never given any of the papers. Unless I get the papers upon which the judge is relying upon, or the defendants, I have no way how to respond. And you have 10 days time from the date you were served with the papers. I was not served with any of the papers. They are moving the court, they are sending me a notice saying that after the judge rendered a decision, he says, he makes his own story. I never been to this man except once, 5 minutes or 5 or 10 minutes hearing. Nothing was discussed about the case. He makes a findings of facts. How can he make findings of facts when there is nothing? No papers, nothing from my side. He issues an order saying that the final paragraph of his order says, unless Mr. David returns the money back to the employer within 10 days from the date of the order, the case will be dismissed as without prejudice. Without prejudice is a legal term. Now, I didn't know at the time the difference between without prejudice and on the merit. So what happens is, this is all a player's game, okay? All players. It's not one person, everybody. It goes to the clerk of the court in Tampa. The Tampa clerk issues a judgment as on the merits, awarding the defendants their costs and expenses. You understand? The clerk alters. The name of the clerk is Donald Brown. He was fired subsequently at the instance of 2 other judges in the same court because he is doing hanky-panky. Okay? I think Patricia Fawcett and another judge reported him as incompetent, so he was fired from the court later on, which I didn't know at that time. Now, as soon as they sent me a copy of the judge's order, I didn't know the difference between these two. I didn't know the jurisdictional issues. I filed what is called a notice of appeal and paid the docketing fee. At that time it was $70 to the court below. So when it goes to the appeal court in Atlanta, the 11th Circuit Court of Appeal, the clerk of that court is required to independently assert whether the case is appealable to the Court of Appeals or not. Okay? Here what they have done is, everything cooked up, the clerk altered it. So clerk says on the marriage, so the appeal court, 11th Circuit, closed their eyes. They're all players, okay? You have to understand this. Like big game. And they know in the appeal court which judge or judges are amenable corporation judges. There are 2 types of judges. One set of judges amenable to political pressure. One set of judges independent, honest people. So the defendant knew which judge or panel of judges are amenable to their tricks. Okay? This is the name of the game. So it's all being arranged through the court's insiders. Insiders means the requirement of the law is that you have to file all papers addressed to the clerk of the court. You can't send it to any particular judge or anything. It goes to the clerk of the court. So once it gets to the clerk of the court, the insiders get the file. And they decide which judge or judges the case should be assigned for an appeal. In this case, my appeal went to a panel of 3 judges. One of them was called Judge Robert Vance, one judge. Second one is Clarence Allgood, third judge, Jail Edmondson. So this is all scheme, okay? Doesn't go to anybody other than in their clique. I get a letter from the court saying that, Mr. David, your case is assigned to case number so-and-so, and come for a oral argument, which is you are given 5 minutes time. Folks, I was going in good faith. I had to fly from New York to Atlanta to argue the case before a panel of 3 judges for 5 minutes. You understand? At that time, I'm unemployed. I will come to that, because what they do is, big major corporations, they blacklist you. Once they blacklist you, doesn't matter where you go, how qualified you are, nobody will hire you, because they will tell a prospective employer, is a pain in the ass. That's the American expression. So nobody wants to hire a person who was fired. Did I do any crime? Did I commit anything? No. Okay, this is the tactics. Major corporations in America. I want the world to understand what is going on. There will be hundreds and thousands of you sitting and listening to me. Okay? So this panel, after hearing the 5 minutes oral argument given to me, and hearing Anne Conway, who came to argue on behalf of the defendants, I don't have a copy of the transcript of her arguments. She convinced them this case is appealable. So this panel of 3 judges issued an order which says affirmed, A-F-F-I-R-M-E-D, affirmed, one word. You will see that. And they issued what is called a mandate. Folks, I didn't know, as I repeatedly told you, the whole thing, because I am a novice, I am a pro se. I appealed to the US Supreme Court. The case number was 86-6168. Before the Supreme Court, the defendants argued that the order of the Tampa court is not a final decision, and as such, the Supreme Court had no jurisdiction to consider the case. But before the 11th Circuit, they have to file what is called a jurisdictional statement. In that jurisdictional statement, they stated the case is final on the merits, it is appealable under 28 U.S.C. 1291. So in the appeal court, they say it is appealable. In the Supreme Court of the United States, they say no, it is an interlocutory order. The smart lawyers, how they bluff the courts, how they get away. Folks, the Supreme Court, based on their pleading, their arguments, denied certiorari in the year 1986. Folks, I thought that is the end of my claims. My Title VII, pension claims, ADA claims, because what these smart lawyers do is, if I fight in the court of law, I get a judgment which may be in millions. Here, they, the chief, the operators or the CEO of this company, and their legals, they pump money to have the judgment, so they don't have to pay the work or anything. Okay? So, 5 years went by. I was working in another law firm in Manhattan. I don't know which firm, I worked a few firms as paralegal. I was reading the law journal, and the law journal clearly stated there is a difference between a dismissal without prejudice and a dismissal on the merit. Folks, you have to understand this. So what happened in my case was the Judge Hodges' order was dismiss the case without prejudice. What the clerk did was he altered the court's order from a dismissal without prejudice into a dismissal on the merits. The reason being, the appeal court can only hear a final judgment rendered on the merits. That was the trick. So when I read the law journal, I immediately filed an appeal to the district judge in Tampa, Judge Hodges, telling him that your order was to dismiss the case without prejudice. The clerk had altered this as on the merits. There is a mountain of difference between these two. Under Rule 59 of the Federal Rules of Civil Procedure, vacate the judgment and issue an order. Judge had no other option because I am telling him what is on the record. What he issued and what the clerk altered, they are different things. So Judge Hodges issued an amended order admitting the clerk had made an error in the entry of judgment and directing the new clerk to amend the judgment of the court retrospective effect from the date of the original entry of judgment. Folks, when I got this, there are a lot of things were happening. And years had passed. Okay. I moved the 11th Circuit Court of Appeals, telling them under Rule 35 of the Federal Rules of Appeal Procedure, vacate the court's mandate seeking en banc hearing. En banc means the entire court should hear the case, because here the mandate was issued long time ago, 5 years ago. Now, as I told you before, under the scheme, the file goes only to those judges they wanted. The rules say, Federal Rules of Appeal Procedure 35 says, what are the things you got to do? Which says you got to give a reason why you want the court to vacate or recall mandate. You have to cite the cases and the case laws, which I have complied with. And the courts had held in the past that when a court lacked jurisdiction, its judgment is a nullity. If you have no authority to hear the case, and you hear the case, that has no validity. That is what is called. If the court lacks jurisdiction, its judgment is a nullity. Now, did the Tampa court have jurisdiction to hear my case to first start with? No, because I don't live within his jurisdiction. He had no jurisdiction over me. So his judgment is a nullity. And also, there's a fraud involved. The clerk of the court, Donald Brown, had altered the court's order. So fraud involved. So when I filed the papers, it goes to the same Judge J.L. Edmondson. The other two panel members, one was bombed and murdered, Robert Vance. Second judge committed suicide. So he was the only judge assigned to this case. And this judge, Mr. J.L. Edmondson, he had already retired. You understand? He retired from the from the United States 11th Circuit as from July 15, 2012. So he cannot hear the appeal filed in the year 2015. That is another thing. The Supreme Court also had held there is no time limit within which to move to vacate the order. There is no time limit. So you can do it any time, even after entry of judgment. So folks, Judge J.L. Edmondson, to whom the case was assigned, on his own, not with a 3-judge panel, a retired judge, denied my motion arbitrarily and capriciously. He had no business. First of all, he is not qualified. He is a retired judge from July 15, 2012. He cannot hear the case. It should be heard by at least 3 active judges. So he instructs the clerk of the court, a young lady by the name I believe newly hired, whatever her name, not to accept any papers from Mr. David on disclosed file. The rules say if the judge had entered a decision when he had no jurisdiction, it is a nullity and it can be opened any time. So what he does, he instructs the clerk not to accept any papers from Mr. David on disclosed file. You will see the exhibit. Folks, I know this judge was wrong 100%. So despite his orders to the clerk of the court not to accept any papers on disclosed file, I submitted 15 sets of my second petition under Federal Rules of Appeal Procedure, seeking en banc hearing. En banc hearing means the entire panel of the 11th Circuit should hear the case, not by a retired judge who is unqualified. Folks, this is all a game plan, okay? The employer is pumping money, it goes to the same route. It doesn't go to the right judges pursuant to the rules. So, I'm getting another letter, another order. This is signed by J.L. Edmondson and Marcus. Marcus is a judge who was in Miami before, and I had a case before him against the city of Miami. And he played the same gimmicks there. And his decision was appealed to the 11th Circuit at that time, and they reversed, okay? Because I was seeking an employment with the city of Miami. I had 98.6 score out of 100. They won't hire me. I sued them, city. So this judge ordered me first to come to America, because I was in India at that time. I said, hell with America. And when I went half the way, I have no flight to travel from London to America. So I called the court, and they said, okay, you can come late. When I went there, city had filed what is called a motion to dismiss my case for failure to hire. So that decision was reversed. Judge Marcus' decision was reversed by the 11th Circuit at that time. And I settled it for about 16 or 18,000 with the city for failure to hire me. Now, this judge, now he is promoted, he is sitting at the 11th Circuit. So him and J.L. Edmondson again denied. Okay, I'm telling the appellate court, folks, you have no authority to hear the case. The case was heard by the Tampa court, which had no jurisdiction. Its clerk altered it Now the judge says we made a mistake and they don't recall mandate. Folks, this is the name of the game going on in the court system. How many people of you who are listening knows how to fight this case? You don't have the legal training. You may be an ordinary worker. Okay? So this is the tactics of AT&T, these big corporations. No wonder this guy is going $77 million in benefits. Mr. Randall Stephenson. They know whom to approach, how to grease the palms of the right people at the cost of the workers, American workers. Folks, now what I did was I filed a petition for a writ of mandamus. Writ of mandamus means you are telling the appellate court, the Supreme Court of the United States, these judges have made grave errors. They can't do what they are doing. They can't deny my petition pursuant to the rules. So everywhere the corruption mill at full swing. I'm getting a letter from the clerk of the court saying that, Mr. David, your petition for a writ of mandamus denied. The court had repeatedly held, the US Supreme Court, in other cases, when a court had no jurisdiction, its judgment is a nullity. Now, what the clerk is doing is pressing the button and say your case's petition is denied. I was in a state of shock. How can the US Supreme Court have two different rules, one for one set of people, another set of rules for another set of people? I am proceeding pro se. I was again, as I said, I am in a state of shock because you have to understand I am an employee, a grieved employee who the employer through their tactics destroyed me. My marital life is crumbled already. Okay? After the Supreme Court allegedly denied my petition for a writ of mandamus in case number 15-9100, I filed yet another petition under case number 16-9624. In this case, I sought the same relief, saying and telling the US Supreme Court that when a court lacked jurisdiction, its judgment is a nullity. This is precisely what I had argued in the previous petition, case number 15-9100. It appears somebody, some smart, maybe law clerk, found out what I am saying is true. So on October 2nd, 2017, the court issued a 5-line order. The order read, my motion to proceed in form of pauper is dismissed. Okay. And on line 3, 4, 5, it says, unless Mr. David pays the docketing fee and submit the petition pursuant to the rule, that's fine. Okay, that's the holding of the Supreme Court in case number 16-9624. We will show you a copy of the court's order. Now, when the court issued that order, one of the clerks employed by the US Supreme Court, a woman by the name Melissa Blarlock, she didn't read or she didn't understand what she was doing. She issued an order on January 17 alleging I have not read the court's order and she is sending my papers back. What she did was she didn't read which case she was referring to. We are not referring to case number 15-9100. We are speaking about case number 169624. So she sent the old paper back to me, including my fee, the 40 sets of brief in 4 boxes, causing the American taxpayer to spend money for her stupid ignorance. When I got this letter, I attempted to call her on the number listed on the bottom of this letter, 202-479-3023. She won't answer the phone. The phone was answered by an answering machine, and which directed me to leave a message for her. I left 1, 2 or 3 messages at different times of the day, the DC time. She never bothered to return my call. Then, when I got the money back from this woman, I sent it to Chief Justice Roberts, requesting him to direct the clerk of the court to do the needful. Chief Justice, in turn, forwarded the letter to the clerk's office, and I am getting another letter from another clerk, which is dated February 16, 2018. It says, in reply to your letter or submission referred to this office by the Chief Justice on February 16, 2018, I regret to inform you that the court is unable to assist you in the matter you present. On October 2, 2017, the court dismissed the petition for a writ of mandamus in case number 169624. This case is considered closed in this court. Your papers are returned herewith. Your $300 check is also returned herewith. Now, what this stupid idiot is doing is the clerk of the court, deputy clerk. He only reads line 1 of the court's 5-line order. Okay, you have to understand. Line 3 says, unless you pay the docketing fee and submit the petition. If the court didn't mean what it says, then they don't have to write that word. Okay, so it is clearly understood that is the intent of the court. I pay the fee and submit the petition, which is exactly what I did. So he returned the check, second time, the first clerk, second clerk. Then I wrote to the chief clerk again saying that that is not what the court is saying. You have to comply with the court's order. Your job is purely ministerial to carry out. Then I get another letter from the same Jeffrey Adkins, dated April 10, 2018. It says in the letter, dear Mr. David, in reply to your letter or submission received on April 9, 2018, I regret to inform you that the court is unable to assist you in the matter you present. Under Article 3 of the Constitution, the jurisdiction of this court extends only to the consideration of cases or controversies properly brought before it from lower courts in accordance with the federal laws and filed pursuant to the rules of this court. Your papers are returned herewith again for the reasons stated in the January 17 and February 16 correspondence. So what he is saying is this super idiot, he is justifying what the first clerk did, Melissa Blarlock, and his own letter wherein he says what he is reading. He doesn't read the entire code. Now, in addition, this supermost idiot is raising a constitutional issue. His job is purely to carry out what the court says. He has no discretion. He has no authority to raise a legal question which should have been raised by the parties in dispute. That is me and the counsel for the defendant. They never raised the issue during the last 38 years. Okay? I wrote to the clerk again, chief clerk. So, okay, you have to understand how the name of the game functions here. The clerk, everybody is a paid agent for this corporation. Okay? Understand, folks? This is a case for vindication of my Title VII, ADA and pension claims. So, you have to understand what is going on here. Every player in the process is a paid agent for the corporation. Now I am getting another letter dated August 10. Dear Mr. David, your paper is received again on June 26, 28 and July 30, 2018 are returned herewith for the reasons stated in the January 17 and February 16 correspondence. Copies of the letters are attached. That's the August 10th letter. Folks, this is like a big joke. Okay? Now, this letter, which he allegedly posted on August 10, 2018, didn't reach me for 4 months and 17 days. What he did was, he was faking the whole thing. He may have done a lot of hanky-panky, which I'm beginning to feel. He went to the post office, got a franked receipt. They have made a deal with the clerk of the court there, or the postmaster or the employees there. Sent this letter to Israel. Okay? And from that letter, when I received in December 29 or 30th of 2018, when I looked at tracking number, it has gone first to Israel. Then when I tracked later, it went to Germany. Then finally it comes to me to India on December 29, I believe. I can't remember exact date, I have the details. So what he is doing is, maybe I had set the legal machineries in motion to investigate him, so he is playing games. You understand? That's the way the clerk of the Supreme Court handles, the deputy clerk. I wrote to the chief clerk again. Chief clerk's name is Scott S. Harris. Scott S. Harris is a Yale graduate, and with JD, he should be able to read the 5-line order of the court, which says, unless you pay the docketing fee and submit the petition. Any idiot, even a child of 5 years, he can read English and interpret, but not a Yale or Columbia graduate chief clerk. Okay, he keeps quiet. Folks, you have to understand that this is a political game, okay, carried out by one of the major corporations in America. Not that these three supermost idiots, the Melissa or her supervisor, Jeffrey Atkins, or the chief clerk of the court can't understand, can't read English. I don't have to teach them how to read the court's order, 5-line order, which says unless, very clearly mentioned, unless Mr. David pays the docketing fee and submit the petition. Simple. If the court didn't mean, then they shouldn't have put it. Okay? So the chief clerk, he keeps quiet. He is licensed to practice law from DC Circuit. I refer him to the DC Circuit. Okay? DC Circuit is supposed to investigate an allegation made against the chief clerk. Okay? He's not a little boy. He's a chief clerk of the US Supreme Court. So they try to whitewash. He says he can do that. They have to read Rule 1, which says his duties are purely ministerial. He has to do what the court commanded him to do, unless there's an exception. You used excessive page numbers in your brief. 1. 2. If you used a different font. Okay, font size, page limit, or used abusive languages. None of them were in my brief. Okay, so this clerk and his deputies were bluffing. Okay, now this disciplinary council hogwassed, justifying what he did or his clerks did. You understand? I don't want to go into lengthy arguments because it should have gone to the chief disciplinary council. It doesn't go to the PO, deputy clerk, acting deputy clerk, or whatever it is. Folks, I also filed a claim for getting my pension at the United States District Court in New York when I reached my 66th birthday in the year 2006. Okay, seeking my pension. I had given the background how the courts below in Florida had played the game in my papers and my amended papers. I didn't ask the Eastern District of New York to reconsider what is being done in Orlando, Tampa, 11th Circuit, and the US Supreme Court. To begin with, this woman, Joanna Seibert, she had absolutely no jurisdiction. Her jurisdiction will be if the cause of action arose in New York. It didn't happen. I was living not there at the time, at the time of what happened in Florida. And when she got the file in 2006, many years had passed from 1982 until 2006. She had no jurisdiction. I'm out of jurisdiction, she is out of jurisdiction. Her role was purely consider my claims, my pension claims. You understand? So instead of this woman, Seibert, considering my pension claims, she kept my case for a period of 7 years. 7 years. The rules say you have to decide the case within 3 years. The issue before her is simple. Is Mr. David entitled to pension pursuant to the employer's pension plan or not? So what the defendant AT&T and Michigan Bell did was they went to a major international law firm by the name Norton Rose Fulbright and Jaworski. They went and saw the partner of the law firm. Okay? The partner of the law firm is a black person by the name Ralph Curtis Dawson. He is the chairman of the Democratic Party's Rules Committee. He boasted in his company's website, which he took it off later, that he has the power to appoint judges. You understand? So they are going to the big gun to fight against me for not giving my pension. So this slut, pardon my expression, I am so mad, she went to the length. She wrote a 19-page order claiming my claims are res judicata and collateral estoppel. I didn't ask her, she didn't have jurisdiction, I didn't ask her. So she doesn't have to make a ruling what happened in Florida. She doesn't know. So this new lawyer representing the AT&T and his co-counsel by the name Brian Wayne Tilker submits papers telling the court to dismiss my claims. Okay? Now what is interesting here is Tilker, who was born on May 5, 1979, he submits papers, affidavit, sworn notarized, certified, alleging he has personal knowledge of me executing a release on August 25, 1981 in Detroit. Folks, the release was signed on August 25, 1981 in Detroit. This guy was born on May 5, 1979. So how old he was? 2 years old. He has no personal knowledge. Personal means personal. That's what he says in his sworn affidavit, which we are going to show you. So his sworn affidavit was perjury. Under the law of perjury, you are asserting something to be true, you want the court to believe. Okay? So what this judge does is, as soon as she gets this, she took her own time. Neither Dawson, the supervising attorney, nor Tilker ever came to the court. Never, ever, in the 7 years. All kangaroo court proceedings. So this old rotten wood takes 7 years to issue an order explaining how the Orlando court action continued, getting materials from Tilker. Tilker had no personal knowledge. He is guessing. Okay? Personal knowledge means you should have personal knowledge. So he made a lot of statements, none of which he had personal knowledge. So here's the evidence. Okay? If he says on August 25, 1981, Mr. David signed a release about which I have personal knowledge, it means he has personal knowledge. He was there, right? So, all his statements, he says how the defendant got a judgment from the Tampa court on the merits. Okay? They didn't get the judgment from the Tampa court on the merits. It was altered by the dismissed deputy clerk, Donald Brown, which he states in his affidavit, affirmed by the 11th Circuit and denied cert by the Supreme Court. So half of his statements were completely false based on hearsay evidence. So what this Rottenwood Seibert is doing is, she's citing his affidavit verbatim at least at 12 places in her impugned order and judgment, justifying Tilker. When I got this, I did my own research to find out who is this Tilker. I never met the guy. So according to the Bar Council, New York Bar, he was born on May 5, 1979. Okay, that's the Bar Council information, available also from the public records. He was lying. I brought it to the attention of the judge saying that, Your Honor, you made a mistake. You can't rely upon his affidavit. It is not based on his personal knowledge. It's a hearsay. She didn't know now. She's embarrassed because she's granting a summary judgment to the defendant to just throw my case out. So now she says in her amended order, Tilker now being an attorney, he can do so while moving for summary judgment. She should have sanctioned him, prosecuted him, reported him to the bar he should have been disbarred. In the meantime, this kid, this attorney, Tilker, he fled to Hawaii because he knew somebody may be investigating. Hawaii is a safe haven for Democrats. And when I complained to the Hawaii bar, they said he is not licensed to practice there, although he is working for a law firm at that time. He is not licensed to practice, so they can't take any action. You understand? I referred this matter to the US attorney at that time, an Indian by the name Preet Bahara. Preet Bahara says he has not done anything wrong. I have his letter on record, Preet Bahara's letter justifying, because they are all Democrats, how you pat my back, I pat yours, you kiss my ass, I will do likewise. That's exactly they are proceeding. You understand? So, Tilker gets away. I filed a complaint against the chairman of the Democratic Party's Rules Committee, Ralph Dawson, with the 1st Judicial Department, where he is practicing law. So, George Dapico, the chief counsel for the bar, files a motion telling the Appellate Division of the Supreme Court, New York, that since Dawson is a member of the disciplinary committee, they can't take any action against him, and the court should appoint or place the matter before another disciplinary committee. I have a 5-judge panel order. Okay, it's a confidential, it is already there in the system, we'll show it to you again. So the matter goes to the Brooklyn Disciplinary Council. They take no action because he's the chairman of the political party. Okay, so they hush up. You understand, folks? What is happening is, what is the issue before the court is my pension claims. Folks, this sucker, this Tilker, submits an affidavit, and he says he got some material from the AT&T's pension plan operator, pension plan committee, dated 2015. According to them, their argument, they have no idea what we are talking about, because in the year I was terminated, in 1982, we had a different pension plan pension plan administrator. 1982. So 18 plus 15. 33 years later, this guy is bringing a letter saying that I'm not eligible for pension, and he submits a partially redacted document, 8 pages only, of the SPD, summary of the plan description, which I traced from the Pacer. So he doesn't want to tell the truth. Understand? Folks, under the OFCCP and regulation IRS 410, I am entitled to 100% pension if I worked 7 years. You understand? What happened was, after AT&T and all the companies started laying off, cutting off their staff, and many people were denied benefits, because one of the tactics that defendant AT&T is doing is get rid of people who have not put in 10 years of service early, so they don't have to pay no tax. no pension. So tactics. The Department of Labor ought to have investigated. The AT&T is a federal contractor. So these agencies, the Department of Labor and the what you call the EEOC, they keep quiet. They are in collusion, in bed with AT&T and major corporations to deprive the workers, the American workers, the benefits due to them pursuant to the laws passed by the Congress. You understand, folks? So this Tilker submits the papers, the judge says yes, Tilker is right, and they're bullshitting. I have no avenue at all. She held a pre-motion conference before dismissing. Tilker never came to the court. Dawson was supposed to come for the pre-motion conference. He refused to come. Okay? Big corporations, they don't want to send their lawyers because their public will listen. Here. So this, I don't want to use the word slut, but she is. This slut says to Mr. Dawson on the phone, Mr. Dawson, you don't have to come for this conference. We will do it on the phone. This is not a time when there is a coronavirus. I'm talking in the year 2006. Okay? So Dawson doesn't come. He says, I'm sorry, I misread my calendar. She grants a summary judgment, denying me my pension to which I am legally entitled. You understand? Now, at that time I'm unemployed because they blacklist you. Whenever you go, they chase you. I got a job with the Port Authority in World Trade Center. I worked there for a week. So by the time they get the feedback, it will be a week. So they terminated me. Okay, no reason. So I had the key to the World Trade Center office. I think we were on the 55th floor. But luckily, by the grace of God, they terminated me. Otherwise, I would have been dead long time ago. So I saw later on when the World Trade Center is burning. Thousands and thousands of people were killed. Maybe the people, the world is beginning to hate us, what we are doing, okay? If our own people living in America are denied the benefits, how you will be treating your unknown friends or enemies, okay? I don't justify what they did. Okay? So here what is happening is the workers who worked, toiled for a corporation are being denied the benefits. Folks, now the AT&T lost everywhere. In the lower court, they refused to conduct a trial. They don't want the trial. Second judge was caught. First judge John Reed, dealing with this woman. I reported him, he resigned in disgrace. Passed the ball on to his buddy. He had no authority, no jurisdiction. And the argument before that court was, I should tender back the money back to the employer before I can sue them. The Supreme Court said no. Supreme Court reversed it, saying that if you are a Title VII and ADA claimant, you don't have to give them the money back immediately, only after the trial. So they lost, second count. Third argument was from the New York court, I don't have to pay the pension, okay? They lost that because the OFCCP should have investigated against the federal contractor. And under Section 410 of the IRS rules, my termination of employment was illegal. I was denied the benefits. I was given lower pay, much lower than other legal analysts employed by AT&T was getting. So there are a lot of issues. And their own rules, IRS rules say I should get 100% pension if I worked 7 years. Now there is one more catch. The pension plan was amended by the pension people, reducing the time on the job from 10 years to 5 years. So that was in 85, I believe, 3 years or 4 years after I was illegally terminated. But my pension is payable many years later when I reach 66. So the question is, which pension plan should be applied in my case? Is the prior plan or the present plan when I reach my retirement age? No answer. Who has to decide that? But the defendant's contention is I quit my job. They still continue to assert I quit my job. They couldn't prove it. Folks, that's like a big laughing argument for a corporation of AT&T standing. They shed crocodile tears saying that we are a benevolent corporation. They screwed so many people up, kept them in the courts. They have no basis to deny me the benefits. So they lost in the Supreme Court because when the Supreme Court issues an order, the clerk won't take it. You understand? Folks, what I'm saying to you all is this corporation, I call it the sucker corporation or the mafia corporation, they deployed every tactics. They used the judges, the clerk, and various other insiders to beat a little guy like me. Folks, what I'm saying is, when we have over 200,000 people dying in America, nobody is going to come and work in America if the world understands how our American system functions, the system of judicial system, corrupt system. I don't say the justices are corrupt, but they are, many of them are old, they don't understand. One thing I forgot to mention, under Rule 22 of the US Supreme Court rules, you are required to submit a paper to the justice assigned to the circuit where the case arose. In my case, it was the 11th Circuit, and the justice assigned to was Judge Clarence Thomas. So I made a motion to Justice Clarence Thomas, or alternatively Judge Neil Gorsuch, to look into this matter. I sent that $300 fee and the papers, they send that money back. You understand? The same guys, because they are afraid if it goes to the justice, they will definitely reverse. Okay? That's the second time I send the check, they send it back. So, what I'm saying to you folks is so much corruption, corporate corruption, because they don't want to have anybody question them. They don't want to follow the rules made for the benefit of the workers. Let us see how many people will be coming to work in America once they understand what I have gone through. Okay? So gentlemen, ladies, I want you, once you get this, give me your thumbs up, agreeing that you support what I am saying. Okay, one click. Also, we are making what is called pooling the resources to make a movie so that the civilized world around the world should know what we think is a top secret among our judicial system in this country before the corona kills everyone. Mr. Randall Stephenson, the CEO, may be going like a bandit with the $77 million. $77 million. Stock ownership, bonus, this and that. Okay? So, what is he going to do with the money? I'm an 81-year-old person. I went to America to picket in front of the Supreme Court of the United States. But everybody was busy with the politics. I didn't have coverage. I came back after I was stuck in New York and New Jersey for 5 months. That too, after we filed a writ in the Kerala High Court in India for me to get a flight back to India and provided by the government of India. The Modi government, although I had to pay double the money for the one-way air ticket. Folks, unfortunately, I haven't received, as of today, my 1,200 stimulus payment. Stimulus payment means when we have a calamity, a pandemic disease, people have no jobs, no nothing, they give money to the world, to the public businesses, so that they can create job. That was granted by the Congress as far back in March 2020. Today is October 7. I haven't got a dime. The reason is there is so much bureaucracy, bungling. I did research. I found out why they are not getting 35 million people. Because these people are workers who worked in America either as citizens now or legally admitted aliens entitled to this money. And they are spread all over the country, all over the world. Every country they have gone or they came from, they have gone back. Now, the agency that should keep their record is called FBU, Federal Benefit Unit. The IRS don't have their record. But repeatedly I told them, the agents, what is the problem? They don't listen. They got what is called some big problem. Okay? The agents. I spoke to as many as 11 agents. As of today, I haven't got the money. They have stories. So, God bless America. Okay? If this rate goes and the workers are screwed, they were made to run like I am done 40 years literally from one kangaroo court to the other to get what is due to me under the laws. These corporations playing games. A time will come, they will burn all these corporations as they do now. Okay? Because people are getting so sick and tired. And I'm sure if they come to India to do what they did in America, those judges, lawyers, they will all be burned. I can tell you that in advance. This kind of tricks, making a deal with the judge, his law clerk going to the corporation, the judge's home, making deals under the table to deprive the people their rights, that won't work in India. Okay? Thank you, ladies and gentlemen. Thank you for listening to me.